they weren't chosen by accident. Jurors in Disguise, a jury investigations podcast, exposes jurors who lied their way onto the jury to secure a guilty verdict. Each episode, owner and founder Mary Rose Peterson pulls back the curtain on real cases, revealing misconduct buried in lies beyond the gavel. Visit us on YouTube at youtube.com/@juryinvestigations.
Hello and welcome to another podcast of Jurors in Disguise. My name is Mary Rose Peterson and I own Covert Ops Jury Investigations. What do we do? I'm glad you asked. We investigate the jury to find the one or more jurors who lied during jury selection so they would be chosen and could then make sure that our clients were convicted. At the beginning of the jury selection, the judge introduced himself and said, "Ladies and gentlemen, good morning to all of you. Before we get started, I need to confirm that all of you were properly sworn in prior to coming up to court. Earlier, when you were in the jury assembly room, you should have taken that oath to answer all of our questions truthfully." The judge continued, "You are here today for what we call voir, which literally means to speak the truth. This process is more commonly known as jury selection. During jury selection, the lawyers and I will be asking you questions to help us determine which of you are going to serve as jurors in this case. We ask these questions to determine if your decision in this case might be influenced by some personal experience or some special knowledge that you may have concerning the subject of this trial, the parties, witnesses, or any other issues that may affect your ability to be fair and impartial in this case. Please understand that these questions are not meant to embarrass you or to pry into your personal affairs. They are intended to obtain a fair and impartial jury to try this case. It is your duty to answer completely and truthfully all of the questions that are asked of you here today. If you are asked a question and you would like to answer privately, then please let me know and I'll have you approach the bench or arrange for privacy at the appropriate time." Next, the judge read the charges against our client. He said the defendant did unlawfully, regardless of human life, kill and murder the deceased, a human being, by discharging a firearm and shooting him. And the death of this person was the result of a discharge of the firearm, and during the commission of said offense did actually possess or discharge a firearm, and as a result of the discharge did cause great bodily harm, death or great bodily harm. Now, how many times did he say discharge a firearm? Let's see here. We have 1, 2, 3, 4. That's very important. Keep that in mind as I continue. After reading the charges, the judge referred to the juror questionnaire that the jurors had been given. And the judge said, quote, "I want everyone to look at questions 9 and 10 for me, please. 9 and 10. All right? Read those to yourself. My question to all of you is there anyone here that because of a personal experience, whether it's in relation to number 9 or 10 or not, but any kind of personal experience and based on the nature of the charges in this case alone, without hearing anything else, the nature of the charges and a personal experience, is there anyone here that feels you cannot be fair and impartial in this case? If so, please raise your hand at this time." There were 11 jurors who raised their hand and told the judge they could not be fair and impartial. None of those 11 were allowed on to the jury. But when they were being questioned, there was one particular juror whose conversation with the judge stood out to me. Here's why. The judge said, "All right, sir, you indicated you could not be fair and impartial based on the nature of the charges alone. Is that correct?" The juror said, "Yes, sir." The judge said, "Can you please explain to us why, sir?" The juror said, "I have family who has attempted to use firearms on themselves. This is more on my wife's side of the family." The defense attorney said to the juror, "Once again, there's nothing wrong with any feelings that you have. We are not asking you to be robotic about anything, but it does appear to me that your family has had to deal with crises with firearms, correct?" And the juror said, "Yes, sir." Then the defense attorney said, "And you heard the state had alleged that this is a homicide with a firearm?" And the juror said, "Correct." What you may or may not know at this point is that my first husband died by suicide. We had been married almost 25 years, had 2 children together. When I got to this place in the transcript, it brought back a flood of painful memories. It still does. Ultimately, our client was convicted, and we were hired by his family to investigate the jury. We found 1 female juror out of the 6 who had not answered those questions truthfully. In fact, we found in a former marriage that she had a domestic violence case where an injunction was filed by her against her husband, accusing him of a crime and purporting to be a victim of a crime. So questions 9 and 10, both, she failed to answer those truthfully. There was later a mutual restraining order filed, which accused her of being the aggressor. We also found that the juror who became the foreperson was not truthful at the very beginning of the voir dire. Remember what the judge asked? This juror did not speak up about a personal experience. This juror did not raise his hand. This juror sat there in silence. In fact, it's worse than that, because while those 11 jurors were being questioned privately by the court and the state and the defense and the defendant, this juror who became the foreperson is outside the courtroom having plenty of time to think about his false answers. Never admitted to any personal experience that would have made him inappropriate for this jury. And you're about to find out that he was the most egregious juror on that jury. If anyone was inappropriate out of that whole jury pool, it was this guy. At one point during trial, the foreperson came in with a black eye. When asked about the black eye, he said he just drank too much the night before. So you're on a jury, and you're drinking to the point where somehow you end up with a black eye. Are you fit for jury service? I don't think so. We found that he had been married to a woman who had 3 adult children from a previous marriage. We also found that in the previous marriage, the reason this woman cited for the divorce was gross neglect of duty and extreme cruelty. That was the grounds for her divorcing the first husband. We found that the foreperson of the jury had married this woman in July of 2001. Just prior to that, when they most likely were dating, we found that the woman's son had been charged with assault on his sister. His sister was babysitting for her brother and said when he came home, he started yelling, and then he struck her in the forehead, leaving a 1.5-inch laceration. In June of 2024, the foreperson's stepson was arrested again, this time for domestic violence. It was reduced to attempted assault, pled guilty, served 90 days in jail, and was given 12 months of probation. That 12 months of probation would have taken him right up to the time when our client was on trial for his life. And we found articles in the same newspaper, this time on his youngest stepson, the one who had walked his wife down the aisle at their wedding. A 19-year-old man shot himself in the head with a .25 caliber pistol just after midnight Monday after attempts by officers to get him to lower the gun. Springfield police officers responded to a call of 2 men and 2 women arguing on a porch. According to a police report, officers arrived to find the young man walking north on Texas Avenue. He held a semi-automatic pistol to his head. He was yelling at his older brother, police reported, and he continued walking. The relationship between the 2 brothers was unclear. Officers attempted to get him to lower the gun, but he repeatedly cursed at the officers, including telling them to just blank shoot me, according to the report. He then shot himself in the right temple while in the yard of a home, and they gave the address. A squad transported him to the hospital emergency room. He was later pronounced dead. The next year, there was an article in the newspaper that had been published by the Foreperson, his wife, and their family, that said, "In our hearts forever, loving you and missing you." On the Foreperson's wife's Facebook page, she wished their son, their eldest son, a happy 38th birthday, and the Foreperson wrote on the page, "Love you. I am proud I get to call you my son." So this Foreperson was present when his youngest stepson took his life right in front of him. I wasn't there when my husband died. Our daughter found him. And I can assure you that if you've ever had a loved one die by suicide, whether you were there or not, that is not something you ever forget. There are sights that trigger you. There are sounds that trigger you. There are smells that trigger you. There are words that trigger you straight back to that day. To even think that this Foreperson was not taken back to that day when he stood in the road and watched his youngest stepson take his life with a firearm is absurd. And yet, that is what the state attorney argued at the hearing that we had last December. Our client's attorney is Michael Efferman, who we've had multiple cases together and I have the utmost respect for. This prosecutor admitted that he had a discussion with this juror after trial. Now, why is the state attorney talking to a juror at all at this point in the case? And why is he just now 2 months later bringing this to our attention, to the court's attention, to the defense's attention, that he had a private convo with this juror, the one that we've alleged misconduct on? I'm watching the judge and I'm waiting to see a look of shock on his face, as was on mine, and to have him stop the state attorney and admonish him. He didn't. He said the first question she asked me, she noted she was the only woman on the jury. She wanted to know why we chose her because she was the only woman. We talked about that. I told her my opinion. I felt she was a leader, and I felt she would do right and would follow the rules. I knew she was an executive director, and I felt that she would be able to follow the rules. Then she asked me about juror safety, and was there any concern about any kind of retaliation about that? I told her I'd never seen it happen in all my years of practicing law. Why is she worried about retaliation? He asked her, was there anything that I did during trial, anything that I said, anything you felt was inappropriate, or that I shouldn't have said, or anything that I shouldn't have done during the trial? She said no, she didn't have any problems with my conduct, although she had questions about the conduct of defense counsel. Okay, so let me get this straight. We're going to take your word for it that that's all you talked about. 40 minutes of conversation with this juror, and that's all you talked about. We have no record of that conversation, and you waited nearly 2 months to disclose that to anyone. Sure, I believe you. Our client was represented by the public defender's office in that courthouse. One of the documents that we received before we began our investigation was a 4-color chart, a seating chart of the jury that was given to us by his defense counsel, who was one of the public defenders. When this public defender was called to the stand to testify, Mr. Ufferman began asking him about the color chart. The defense attorney said the reason for the color is we teach voir dire to younger people. If everything is in one color, you're never going to be able to reach into your chart to quickly find something that's important to follow up on. And I'm showing the court we use the old 5th grade 4-color pen for the chart. When they're picking the jury, he said we keep this chart in front of us. We also discussed pros, cons, who we liked and who we didn't like, and we made our decisions off the chart. So the court has a set of questions that they ask that's handed down in a laminated brochure, for lack of a better term. We go through questions 1 through 11. That's the juror questionnaire that I was referring to earlier. Remember, I read you questions 9 and 10. The defense counsel said, we get down to, do you have family or relatives or close friends in law enforcement? We're always interested in that. That doesn't necessarily mean that we're not going to keep the persons. That's something that we're going to keep an eye on. Then, have you or anyone close to you ever been the victim of a crime? We always want to document those for a circle back in case we need to. And most certainly, the judge always does say, is there any other reason we haven't discussed as to why you may or may not be a good juror? I think the judge also at some point in preliminary instructions will say, it's not that we think you can't be a fair juror. This just might not be the right case for you. Mr. Ufferman then said, now during jury selection, in this case, did you rely upon the jurors' answers in deciding whether or not to either ask for a cause challenge or to exercise a preemptory challenge? Defense attorney said, yes, sir. This was a 2-hour evidentiary hearing, which is why I've just picked a few parts of this to read to you. Mr. Ufferman said, so if you were aware at the time of jury selection in this case that the foreperson had a stepson who was involved in an incident of gun violence that resulted in his death, knowing that, would you have inquired further of this foreperson during the jury selection proceeding? The defense attorney said that is something that we would have done a circle back on. Absolutely. Commonly, if someone says, well, I have, somebody that's been a victim or died by gunshot, the judge will say, well, are you okay to talk about it in front of the panel, or would you like to come up and we can talk about it at a sidebar? Absolutely, we want more information on that. Just by the nature of somebody dying by gunshot is something that I need to know about. Mr. Ufferman said, well, if hypothetically that incident involved the police and involved an incident in the driveway of the house where the shooting occurred, would you consider those facts to be pretty similar to the facts of this case? The defense attorney said, once again, if we're talking about driveway in front of a house, yes, that is something that I'm going to say, wow, this may be too close for comfort. Mr. Ufferman said, and is that something that if you would have explored further and confirmed those facts, that you believe you would have used a preemptory challenge on this foreperson? The defense attorney said, we would have used the preemptory based on the fact that a close relative had died by gunfire, especially if you're talking about if the young man had died with a headshot. I have an alleged victim in this case with a headshot. That's something that we would not have looked to keep him on the jury for. I would have, and once again, I didn't have the information, but if I had that information, I would have counseled our client that, there's really no reason to leave that person on this jury. Mr. Ufferman then said, if hypothetically, if it had been brought out during jury selection, if the foreperson had disclosed he was married and his wife in a previous marriage was the victim of domestic violence, and that incident involved the use of a firearm, would that have also caused you the same concern about keeping this foreperson on the jury? Defense attorney said that in of itself would have been a circle back. That would have been a major concern. We're stacking here, and 1 would have been enough to preempt. 2, we most certainly would have preempted. 3, we would have said, Judge, I don't care if this person is saying they could be fair. There's just too much that's similar to this case. We are asking for cause. When a juror is telling us that they are either victims of gun violence or somebody close to them is a victim of gun violence or somebody's wife may have been a victim of gun violence, we know deep down that this is something we need to know before we can make a decision whether or not we preempt. From the defense side, we would lean towards, if not absolutely, preempt. Next, the prosecutor began to question the defense attorney. You can agree that there's really no science, no known reliable science to jury selection, right? Defense attorney said, I would agree with that, but as you said, we're in this thing for coming up on 30 years apiece when a juror is telling us that they are either the victims of gun violence, or somebody close to them is a victim of gun violence, or somebody's wife may have been a victim of gun violence. We know deep down that this is something we need to know before we can make a decision whether or not we preempt. From the defense side, we would lean towards, if not absolutely, preempt, based on those answers because of what our case was. Prosecutor said, well, certainly those answers aren't the end-all, be-all either, right? Defense attorney said, the answers are the only thing we have to go on. If that was brought up to me during jury selection, that would have me using the red ink, circling with green to circle back, because that preempts everything else I need to know about that juror, is whether or not the facts of my case are too close to home for this juror. And I could never know that unless that juror talks to me about it. When we had all of the other jurors that did talk about it, I can only have to believe that the lack of him telling me was the truth. At this point, it was abundantly clear in my mind to everyone in that courtroom that the defense attorney would never have allowed this juror on the jury had the juror been truthful about his stepson. Then the prosecutor starts hammering the word close. That the word close is subject to the interpretation of the reader or the listener, right? Defense attorney said it's always subject to the interpretation. But if you're talking about a stepson or somebody who is a wife, I think that to not talk about them in the context of this case is something that should have been brought up. On the flip side, if my son had committed suicide in my front yard, I don't care how old I am, until the day I die, that is going to be a core memory. Yes, it will be. Prosecutor said, so you would quantify a person who shoots himself in the head as a victim of gun violence? Yes, I would. Defense attorney said, is a victim of a gunshot. Keep in mind that in this case, we also had a victim of a gunshot, and that is too close for comfort for a defense attorney to not deal with, either in voir dire or at sidebar. And quite frankly, even if I couldn't get a cause, if you look at that chart, you see all of the no's, you're going to probably count 10 of them. Based on what I'm learning today, the no would have been in position 2. If someone attacked, my wife before we were married with a firearm, I would consider her a victim. So getting into whether or not somebody is a victim of gun violence if they kill themselves, one, it's somebody may have shot themselves in the head, and we have allegations of a headshot in our case. I can't leave that without discussing it, without finding out whether or not it will truly affect that person. If somebody is talking about gun violence against a relative, I need to know about that. Because once again, if we're stacking everything that I'm finding about here today, I'm going to preempt that person because it's just too much to leave that person on this jury, no matter how fair they may say they can be. And my client had a right to hear that, to counsel with us. Because even if I said, well, you know what, maybe he's not so bad, my client had the right to hear what that person had gone through to say, well, you know what? I don't want him on the jury. It's the absolute lack of knowledge and information that led us to not use the preemptory based on everything that I'm hearing today. Prosecutor said, I'm not disputing that. What I'm trying to get at is, do you agree, sir, that this Foreperson's decision on whether or not to disclose his stepson's suicide from 2003, his former stepson, is dependent on his understanding of the word close? Do you agree? Defense attorney, no. You would have to ask him that. I am not that person. But the fact of the matter is, that is information that, had it been brought forward, would have been part of our line of whether or not to preempt him. These are all facts that are going to be similar to our case. These are too close for comfort for a defense attorney to say, hey, let's keep this guy. Prosecutor continued to push. Right, but you would agree it's subjective. The word close means something to you, right? Defense attorney, well, the way that I look at it is seeing somebody or knowing somebody that had died by a gunshot head wound with a head wound, whether or not you're close to it, that is not a normal everyday experience for the average citizen. That is just out of the norm for people in this country. And when you're sitting here and the judge has announced this is a case of second-degree murder with the use of a firearm, we need to know whether or not somebody has been affected by gunfire and whether or not they can be fair. So whether or not they were close or weren't close, we need to know whether or not they can be a fair juror in our set of facts. And if somebody says headshot and my wife was a victim of gun violence in our front yard, we would have used the preempt. Then the prosecutor moved on and said, regarding question 10 on the verdict form, the word close in question 10 is used the same way as the word close in question number 9. He went on and on and on, arguing whether or not this juror considered his stepson to be close to him. Defense attorney continued, had I had this information, this man would not have been on the jury. That's the end of it. Based on what I found out, I would have preempted him. I would have counseled my client. Even if he wanted him on the jury, I would have said, this is a bad idea based on this information, but if you want me to keep him, I'll keep him because it's your jury. But no, we can go back and forth, but the core issue here is that the man would not have been on the jury with the information had I had it. And I cannot have that information unless it's told to me. Amen. Done. How many times did the defense attorney say he would never have allowed that juror on the jury had he known, had he spoke up, had he been truthful, had he been forthcoming, had he admitted to his son's violent death right there in front of him? Repeatedly, over and over and over. And what did the prosecutor have to argue? The definition of the word close. Mr. Ufferman was given the final word. He said, concealment is the issue in this case. I think if everything alleged in Ms. Peterson's report is true, including her assertions that the foreperson was close to both stepsons at the time of his death, then there would have been materiality, and the defense attorney's testimony supports that. I don't think it's due to any failure of the defense attorney to ask any questions. The questions are asked on the questionnaire, and the court itself asks questions. I think your question was a broad enough question that a reasonable defense attorney could rely upon it. And yet, at the end, the prosecutor said, no matter how many times they say it, there's nothing about this case that is similar to those cases. What? In this case, the victim died by gunshot to the head in a driveway. The stepson of the foreperson died by a headshot with a firearm in a driveway. The foreperson's driveway, I might add. Then he said there's nothing at all on the record in this case that is in any way similar to the prior incidences alleged regarding the foreperson. What? He stood there and said that with a straight face. And everything about this case would have been a trigger for that foreperson. The last thing that the prosecutor said with a straight face is, Judge, at this point, there's no reason for the court to order the jury interview. On a public policy, from public policy standpoint, allowing a juror interview can have an effect, a chilling effect, not only on potential jury members, that if they come in here, do their jobs, they will be subject to extra scrutiny beyond their verdict. Yes, you're right. If a juror comes into a courtroom and lies to everyone's face, which I might add is a third-degree felony, they should be punished. They should be held accountable. But they're not. Here's a state attorney saying, give him a pass, Judge. Don't hold him accountable. Oh, he will be subject to extra scrutiny. You're absolutely right, he will be, because he lied. And he denied our client a fair trial. A juror came into court, lied to everyone's face, became the foreperson, and ensured our client's conviction. And now we have a state attorney saying that doesn't matter. It didn't matter. There's no similarities here. This juror didn't do anything wrong. What? He did everything wrong. State attorney said it also potentially allows the attorneys to snoop into the minds of the jurors, to snoop into matters regarding jury service that are not our business. That's not your business? You don't care about the Constitution? It's just words on a piece of paper? Someone's civil rights don't matter to you? It's not your business? And if you investigate them, you're snooping? He said, and the court at this juncture should deny the motion and allow us to proceed to the motion for a new trial, which should also be denied, so we can proceed to sentencing. Aha! That's what you wanted all along. Proceed to sentencing. Mr. Ufferman was allowed to respond. He said, I will note that the state spent most of its argument talking about materiality. I've handled several of these jury investigations. This is the most material of any of the ones that I've dealt with. To have a gun violence in the front yard that results in a death and a shot to the head, I would submit, and the court can obviously disagree with me, but I would think that honestly the state, reasonable prosecutors, reasonable judges, and clearly reasonable defense attorneys would not allow that juror. It's not an indictment on a juror to not be selected on the case. Jury selection is about finding jurors that, based on their background, are the right fit for that particular case. If a juror is not selected or peremptory challenged or cause challenge is utilized, it's not because the juror has done anything wrong. It's simply because something in their background makes it so they're not an appropriate fit for that particular case. This foreperson was not a fit for this case. The prosecutor made a big deal about proximity and time. When you have a stepson die by suicide, that's not something that you erase from your brain, perhaps, ever. There's some incidences that are so significant that there's no approximate, there is no passage of time that would cause them to be erased from their memory. The motion to interview jurors, the motion for a new trial, was by the judge denied. Remember at the beginning of the jury selection what the judge said to the jurors? The broad question that he asked them? This opened the door for the juror to step up and be honest. And the fact that he did not respond to this judge's question indicated concealment. I knew the judge wouldn't want to be the one. He did not want to be responsible for opening that door and giving a reason for him to grant this motion. Number 45 of the judge's denial said, here, there is no allegation that juror 207 was actually biased and failed to make a disclosure in response to the court's inquiry. Obviously, such an allegation would constitute concealment. However, a careful review of the record reveals that juror 207 was not, quote, squarely asked for, end quote, information related to a suicide or any other violent non-criminal incident involving a firearm. Number 46 says, therefore, the court finds the defendant has failed to establish concealment. Do you think the juror concealed his stepson's suicide? I do. Do you think it was intentional? I do. Do you think that had he been truthful, he would have been struck from the jury? I do. For all the foregoing reasons, the court finds that the defendant has failed to meet his burden. It is hereby ordered and adjudged that the motion to interview jurors is denied. What do you think? Do you think that the juror who became the foreperson knew what was asked of him at the very beginning? I do. Do you think that the foreperson intentionally remained silent and concealed his stepson's suicide by firearm? I do. Do you think that the judge's speech at the very beginning was enough to prompt him to speak up? I do. Another juror did, and he was struck from the jury. Do you think that this foreperson came in with an agenda? I do. Do you think that this foreperson was biased against our client? I do. Do you think this foreperson had something to do with him being convicted? I do. Because the facts of this case do not line up with a guilty verdict. The judge wanted a conviction, and that's what he got. When we proved that the conviction was tainted, he ignored this and upheld it. Our client was sentenced to 40 years in prison and is now at the reception center on his way to his, quote, permanent camp. Next, I'm going to talk to our client's parents so you can hear a little bit of their side. Help me welcome them. Hey.
Hey.
Oh, it's good to see y'all. Have you been able to talk to Andrew at all?
Yes.
Yeah, we've been able to, he calls us. It's a lot harder to call us, but he tries to call me every day and he can't always get to the phone at night to talk to John. But he's like, yeah, it sucks. But he goes, I'm okay. I'm always okay, Mom. Which is so kind of him to like comfort me in that way because he doesn't have to. But he's like, I'm always okay. And I'm like, thanks, Andrew. You know, I said, I know that you're lying, but
He's Andrew.
he's the same.
He's the same kid. He's strong. He's brave. He's courageous. I mean, he's still Andrew.
Yeah, that's awesome.
I will say that the things we taught him, you know, to respect law enforcement, about, you know, the Constitution, all of the things, Second Amendment, you know, what to do and not to do, some of those things, he's like, well, he's realizing those aren't necessarily true. And, you know, he's experiencing, you know, how important the Fifth Amendment is and how important the Second Amendment still is. And what's the good of being allowed to carry if you can't use it to defend your life.
Right. Well, he's a good man. You've
Yeah.
raised a good man, and he should not be going through, neither should you, what you are. But you know, we as believers, we know God has a plan. It has rarely made any sense to me. And I spent 4 years, 2 months, and 13 days going, really? Seriously? This is your plan for the second half of my life? Come on now.
Right.
But, you know, I look back and I mean, now I get it. You know, if we had not gone down that road, I wouldn't be talking to you. So, what are some of your thoughts as far as just our criminal justice system in general, based on what
So
you
absolute failure.
Yeah.
Criminal justice, not only criminal justice, but law enforcement is, in this case, in my eye, the primary failure is law enforcement.
Yeah.
Without a doubt.
Like the sheriff would get up and say, we got a murder off the street out before knowing any evidence whatsoever.
Okay, they came to the scene with the narrative and they made that narrative fit. They investigated it only so far. They did it. I mean, we have all of this information. We have it. The crime scene analysis, the bullet trajectory analysis, everything that we have put together just solidifies Andrew's statement.
Right.
That if this was self-defense.
That's why I said when you put all the pieces together, it don't make any sense.
No,
Yeah.
the math doesn't match.
No, the math, it doesn't add up. Martin would always say it doesn't pass the smell test.
Right.
You know, it just doesn't make any sense. And I know, Chris, when we first talked, I said the only thing that makes sense is you had a juror on that jury who wasn't leaving that room until Andrew was found guilty. So now we know that that's true. It goes against everything that we stand for, not just as Americans, but as lovers of our Constitution. And it goes all the way back to the founding fathers. They gave us these rights.
Yes.
And just because a state attorney and a judge who's the state disagrees does not mean that they're right.
Which road? So my mother, her family lived on the road for as long as I can remember.
Mhm.
And so that 2 acres is the place where the homeless camp was. And with 40 plus people, cars coming and going all hours of the night, 2:30 in the morning, 3 o'clock in the morning, never stopped. They would come in for 2 minutes and leave, come in for 2 minutes and leave. They were loud. They were doing drugs there. There was so much drug paraphernalia. It was just disgusting. Rats, like it smelled like urine back there. But yeah, it became an unsafe place to be. One of the men that was actually at the trial, I remember him peeing in front of my daughters. Even on the stand, they admitted to, using meth. And they did not have respect for the neighborhood. They did not care.
Wow.
It was just a disaster. It was kind of scary. Like for my daughters being over there one night, they would hear the women coming to get water, and they're like, "Mom, there's people like getting water." Scary.
How old were your daughters then?
9 and 7.
Yeah.
9
That
and
would be
7.
scary. Coming in the
Mhm.
middle of the night, somebody outside your door.
It just would not go away. They would not leave. It just got bigger and bigger and bigger, and more trash and more junk and more stolen stuff and the only reason we cleaned it up is because our daughter Nikki was going to build a house out there on that property. They were a young married couple, so it would have to be a process. That's why they were clearing that land. So 2 weekends prior to this incident, the whole family, they bought four dumpsters. Yeah, and they had a big skid steer, a big machinery, because there was a gutted truck that was there. They wouldn't move it, so they had to just pick up and move it with a big machine. And Andrew helped. He was knocking down their homeless shelters to
Right.
clear it off with the skid steer. So I think that's why they hated him so much.
It was just manipulated. They tried to make Andrew out to be the initial aggressor.
He wasn't.
Wow.
I have no doubt he was not. There's no way. Yeah, they were stealing electricity, so they had a refrigerator going, they had microwaves, they had lights, they had safes, they had everything. This was a complex homeless camp.
Yes.
Yeah.
I mean, while we were cleaning this up, people would drive. So many cars would drive down the street, and we're like, "Whoa, what's going on? Why is there a dumpster here? Why is there a skid steer? What's happening here?" And they would just turn around and go right back out.
That I will say that's why Andrew always had his rifle on him. He would just watch this stuff happen all night, and he was protecting my mom. Like my mom was there by herself at this point. My stepdad had died.
Tell me a little bit about his background with firearms.
Oh my word! Andrew started shooting probably when he was 7. First obviously little 22 short rifle. Learned how to use that. I think we may have had a BB gun here or there before that, but his first real rifle, he's probably 7 years old, I believe.
Wow.
And he's been shooting ever since. He's very proficient, he's very good. He's not a novice shooter by any means. That's why all this stuff, none of this makes any sense. He knows the difference between pointing and raising. He knows the difference between a perceived threat, a real threat, or I need to act immediately. He was trained that the end of that muzzle is like a laser. Whatever it crosses, you will destroy. If you don't want it to be destroyed, don't let it cross your muzzle. He's very well aware of this.
Well, John taught him. He was a ranger in the military, so he knows his ways around guns. So not only did he have his dad's expertise, he had his grandfather who was a gunsmith for 50 something years. I mean, he had trained Andrew shooting
Repairing
guns, and
Yeah.
he taught him. They both taught Andrew everything they knew.
Yeah.
And trained him and spent time with him. So he did not take any of this lightly.
Right.
So.
Which makes the accusations against him absurd.
Yes, absolutely.
Because he's not somebody that would have overreacted.
No, he absolutely would not do that.
Yeah.
No, never.
I still can't wrap my head around the fact that the state even prosecuted this.
Me either. Yeah, the night before, the last time we saw Andrew before this happened, he was at his little sister's dance recital. His car was broken. He found a ride. He made it happen. He made a way to get there every time, no matter what. Never missed one.
That's so sweet.
Okay.
Oh.
Initially, we don't know what happened, but no one did a bullet trajectory analysis. No one did a crime scene reconstruction. Nobody put the math together. Nobody put the autopsy and overlaid that all together, which is so crystal clear.
Every news outlet that has covered this, every YouTube, whatever, everyone talks about how bad it looks, how the back of the windshield, he did it from behind. That's not true though, because if you look at the bullet analysis, they're all coming from the side.
Shooting from the back as they're leaving makes no sense.
No.
Right.
They're
Right.
leaving. This
Yes.
is a young man who would have stood
He
down.
had rifle down and was just trying to de-escalate the situation
Right.
to go get his dog, and they would not let it go because you know why? They're high on methamphetamine, 1900 nanograms per milliliter of methamphetamine in the toxicology report.
You had the passenger at trial admit that they were both high out of their minds. It should have been a mistrial because there was reasonable doubt.
No plumbing.
Yes.
Absolutely.
Agree.
Yeah.
Yeah.
Right. This was so clear. That's how I was just shocked, absolutely shocked, because the trial went very well, I felt. And then for that was like, are you kidding me?
Yeah.
Did you pay attention? Were you awake?
Judges are so biased.
Right.
Clearly, look at what yours did to you.
Yeah.
You know, sided with the state. That I was reminded of the conversation that the state attorney had with the other juror that we found that was guilty of misconduct.
Yes, that was so bizarre.
That's not.
I was
okay.
sitting next to you, and I almost gasped.
I know. I know. Me too. I was like, what?
It was. I mean, the only thing that makes sense to me is that she was fishing. You know,
Right.
she wanted to know if he
Out
knew.
of the view.
I know. I'm trying to put you in the
I'm
view.
trying to know.
You're better looking than me, so.
That's it.
And I kept watching the judge, waiting for him to just be like,
He was deadpan.
Yeah.
He
You
didn't
know,
even like
no,
flinch.
wasn't even the least bit.
Concerned.
Yeah, I never realized how broken our system was.
No, no.
Me either.
I had no idea.
The thing is, we make laws. And if you're speeding 85 and 55, you get in trouble. You broke the law.
Right.
Plain and simple. Okay, well, give you a ticket. I get it. I understand. But when you don't do anything wrong, and the next thing you're asking a juror to think whether they're guilty or not.
Right.
It seems ridiculous. Like,
It does seem
there's no
ridiculous.
facts.
Yeah.
There's no nothing. You're just making stuff out of thin air.
Yes. Yes.
What? And please believe me because I'm a state attorney.
Yeah.
Why?
Yeah.
Right.
Yeah.
I know what the law says. I've read plenty. I spent better part of 4 years in law library just reading, just page after statutes, case law, and everything else. I know what the law says. I'm not completely stupid, but yet they don't follow it anyway. They don't even
Right.
say denied. They said PCA.
PCA. Yeah.
Yeah. What the PCA means?
I had to look it up. Yeah. Pure cure.
What does that mean?
It's all Greek or something. I don't know what it is on purpose, just to confuse people.
You're at war. You're at war with the state, and they will win at all costs, and they will lie and they cheat to
Yes.
do it.
Oh, absolutely.
It made me sad for the public defenders who worked so hard, and I know Jay worked so hard on your case and was so vested emotionally, not just
Right.
physically, but emotionally vested in this. And for him to take the stand and say, I never, ever would have allowed this juror. And then for the judge to just say,
Right. Well, Michael, who helped him, he
Yeah.
almost quit. Like he's like, why am I doing this?
wow.
Like he put his heart and soul into it. You know, Jay was kind of training him, and he's like, I don't understand this. He's like, I didn't realize it was this bad.
People who hear about the things that jurors say and do, and that they're allowed to stay, and they're not only not interviewed, they're not prosecuted, they're not punished. What that juror did to you and your family is a crime.
Thing. It's a quote from John Adams. It's more important that innocence be protected than it is that guilt be punished. For guilt and crimes are so frequent in this world that they cannot all be punished.
Right.
We need people like that again in positions of power.
Thank you for talking with us.
Yeah,
you.
thank you so much. It was nice to meet you, Martin.
Nice to meet you.
Nice to meet you too.
Thank you for watching. Be sure to like and subscribe. And remember, the courtrooms may be silent, but we won't be. We will speak up, we will speak out, and we will always speak the truth. Thank you and God bless. That's all for now.
All it takes is one to convict an innocent person, one Trojan juror, one biased agenda, one hidden motive. That's why we investigate juries. We identify the sinister players and expose them. Jury investigations. Our number one objective is to get you back into the courtroom, because a guilty verdict doesn't have to be the end of the story.